back with What in the Law podcast. We are shooting again today from the Sweet and Savory Pie Bar on 5152 Centennial Boulevard, where they have amazing pies both for lunch, dinner, and dessert. They are insanely good, and they're so good that I'm going to talk a little bit more about insanity. We have some cases in the news where people plead not guilty by reason of insanity. In some other states besides Colorado, they call the same thing guilty but insane. What does that mean? Well, in Colorado, not guilty by reason of insanity basically means you cannot determine right from wrong, and you have such a diminished mental capacity that you cannot control your conduct and cannot understand what is wrong with the offense you did. This is rarely successful and is only normally used in the most serious cases. If you are found not guilty by reason of insanity, it's not that you are really not guilty and you get to walk free. In fact, what happens is you get sent to the state hospital, which is really just as secure and just as strict as a prison. However, they are designed differently and are focused more on providing mental health treatment during your stay there. How long you are incarcerated in the state hospital depends on whether the doctors feel that you remain a danger or whether you are safe. This does not have any maximum period of time, and in certain cases often can be for the rest of your life. In fact, in the very serious cases involving homicides, it is very common for someone who is sentenced after being not guilty by reason of insanity to that state hospital to never be released. That's also one of the reasons why insanity is rarely used in misdemeanors or low-level felonies. Even if you are insane, if you're facing a misdemeanor or lower-level felony, you don't want to be found insane in most cases, because your stay at that state hospital could be far more strict and far longer than might happen to you if you were simply found guilty but not insane. So these cases can be very contentious. They involve often disputed testimony by one psychiatrist for the state saying that you are sane, and then a defense psychiatrist saying you are not sane. What other witnesses say about your life and your background and what your overall history is can be extremely important in whether or not such a defense is going to work or even be an option. But it is not something that is easy to do. It is very, very rarely successful, and normally it is only raised in the most serious cases where the person is looking at spending most, or if not the rest of their life, in prison. So it's a little bit to think about when you read about these different stories regarding people saying they're insane. And I'll see you next time on What in the Law podcast.